Jury system has been used in England and Wales for over 800 years, tracing its roots back to the 12th and 13th centuries. It was considered to give legitimacy and diversity to judicial decision-making, acts as a constitutional check on state tyranny, and functions as a school of citizenship. However, jury service is pretty expensive and time-consuming. In 2025, the Leveson Review proposed restricting jury trials to tackle criminal court backlogs, specifically by limiting defendants' right to elect jury trial in either way cases and removing juries for complex fraud offenses. Today, I want to take you back to the history of the jury and talk about why it matters in our current criminal justice system. First, what is a jury? In England and Wales, a jury is only used in the Crown Court, which deals with the most serious crimes such as murder, rape, and robbery. It is a group of 12 randomly selected citizens tasked with deciding if a person is guilty or not guilty of a crime. If guilty, a judge will then decide on the sentence. After hearing the evidence and often jury instructions from the judge, the group retires for deliberation to consider a verdict. In some cases, the jury must reach a unanimous decision. A jury that is unable to come up with a verdict is referred to as a hung jury. This typically results in a mistrial, and the case may be retried with a new jury panel. For justice to be done fairly, jurors must remain impartial and should only consider the evidence presented to them in court by the prosecution and the defense. They must not look for information about the case or the people involved online, or read news items about the case, as this may bias the decision. A jury cannot and will never be asked to explain its reasonings, so even after a case is decided, a juror can never discuss or review what took place in the deliberation room, as this would again amount to a contempt of court. Juries are only used in approximately 1% in the criminal trials. Most of the cases are decided by judges alone, and even when a jury is used, they need to follow the instructions from the judge. So there's really limited things that a jury can do. However, in the past, juries have actually played a huge part in determining whether someone is guilty. In early history, there wasn't really a profession of judges and lawyers. Until the end of the 12th centuries, criminal cases were determined through trial by ordeal. Under this system, the accused underwent a painful and often dangerous ordeal, such as being forced to pick up a red-hot iron bar or pluck a stone from a cauldron of boiling water. If their hand had begun to heal after 3 days, they are considered to have God on their side, which was a proof of innocence. Another popular ordeal involved water, so the accused would be bound and thrown into a lake or river. If innocent, they were expected to sink. The jury was first mentioned in Magna Carta, which guaranteed a free man the right to the legal judgment of his peers. This marked a shift away from trial by ordeal towards an altercation between the parties. Juries actively took part in proceedings such as disputing evidence, challenging witnesses, and drawing on their own personal knowledge of the case. Only with the rise of the legal profession in the early 19th century did juries begin to take on a more passive role that we recognize today. Now, what is so special about having a jury? The special thing about jury is its diversity and representative nature. So a jury is selected at random, which in theory cancels out individual biases and prejudices to form a representative cross-section of society. This stands in huge contrast to other members of the judiciary. So if you look at the judges, the lawyers, the barristers in court, they are and remain a highly homogeneous class, characterized by being male, white, upper middle class, and middle class. Despite the creation of the Judicial Appointments Commission to replace the tap-on-shoulder approach with a more meritocratic selection, evidence shows that systematic bias persists. As the former Lord Chancellor Liz Truss noted, fewer than 1 in 10 judges comes from ethnic minorities, and only a quarter went to state school, meaning the bench often fails to represent the society that it judges. Given the predominance of white and male judges, there is a systematic tendency for judgments based on male life experiences to prevail. Homogeneity then becomes mistaken for neutrality. While a judge may be highly trained, they remain a single individual and often case-hardened by years of hearing similar narratives, which can breed cynicism or a pro-prosecution bias. This collective nature of the jury acts as a structural remedy to the individual subtle biases that no amount of judicial training can fully replicate. When former Justice Secretary Jack Straw attempted to curtail jury rights, the Bar Council warned that such moves would disproportionately affect black defendants as the random selection of jurors foster legitimacy among minority communities that neither judges nor magistrate command. The second special thing about a jury is that it acts as a constitutional check on the state. So a jury possesses a secret power, which a lot of people don't know, including me before I studied law. It's called jury nullification. It basically allows a jury to return a not guilty verdict despite evidence beyond a reasonable doubt. This is usually applied when a jury believes that the law is unjust or is applied unfairly in a given case. The jury in effect nullifies the law. This is deeply rooted in the US history, most famously used by abolitionist jurors who acquitted those who helped slaves escape under the Fugitive Slave Act. In the UK, jury nullification is also used in the case of Dr. Leonard Arthur. In this case, the baby, John Pearson, was born with Down's syndrome and abnormalities in his lung, heart, and brain. So the doctor prescribed an opiate-based painkiller to be given as required. Then the baby died. The doctor was then reported to the authorities, and he admitted to the police that the effect of the drug given, apart from being a sedative, was also to stop the child from seeking sustenance, and that was his actual intent. He was then charged with attempted murder. During the trial, experts were called to give evidence to the case. The president of the Royal College of Physicians said that it is ethical, in this case of a child suffering from Downs, and with a parental wish that it should not survive, to terminate life providing other considerations are taken into account, such as the status and the ability of the parents to cope in a way that the child could otherwise have had a happy life. Carmen, his lawyer, argued in his closing remarks. He could, like Pontius Pilate, have washed his hands of the matter. He did not, because good doctors do not turn away. Are we to condemn him as a criminal because he helped two people at the time of their greatest need? Are we to condemn a doctor because he cared? According to the Black Letter Law, if someone committed murder, then they should be convicted of the crime. It doesn't matter if you sympathize with the person, it doesn't matter if you think it's ethical to convict them or not. But despite what may have appeared a confession to the charge of murder, the jury acquitted in hours. Their verdict has been construed as a refusal to convict a doctor of murder for allowing a severely handicapped baby to die, even if the law was against him. It brought to the public's close attention of the dreadful dilemma of the doctor in this situation and triggered debate on the ethical questions involved. As de Tocqueville observed, a jury is as direct and as extreme a consequence of the sovereignty of the people as universal suffrage, transforming the ordinary citizen into the democratic branch of the judiciary. On the other hand, professional judges are bound strictly by the letter of the law and the requirement for reasoned judgments, meaning that this democratic safety valve is lost in bench trials. It must also be noted that criminal law is not just for dispute resolution, it's not just to find out whether someone did a certain act, but also for public denunciation. Determining culpability and whether one is guilty requires a moral assessment by the community, not just a technical finding. Critics of the jury system would argue that the guard against tyranny function is anachronistic in a modern democracy with a robust separation of powers. Today's judiciary is constitutionally independent of the executive and legislature, and routinely hold the government to account through judicial review and is bound by the Human Rights Act of 1998. A professional judge is arguably better placed to resist political pressure and apply the law objectively than a jury, which may be swayed by emotion, prejudice, or extra-legal considerations. However, Griffith argued that while judges are independent of the government, they remain part of the state machinery, often sharing a cultural and educational background that leads to a conservative interpretation of the public interest. Besides, the justification of the jury is not by their efficiency or reliability at finding facts, but that their involvement is necessary to allow for jury equity, which means decision based on fairness rather than just strict law, and also to prevent a monopoly of the justice system by professionals. The third special thing about jury is that it acts as a school of citizenship, fostering public trust for the justice system. De Tocqueville argued that the jury teaches citizens to enter into the mind of the judge, instilling a sense of responsibility and duty. Research indicates that the experience of active civic engagement offers jurors a sense of voice and procedural fairness, leading them to report higher satisfaction and a stronger belief that the courts function honestly. Without the jury, we risk alienating the public from the law, transforming the courts into a distant technocracy rather than a shared democratic endeavor. But are juries actually that fair and accurate? Or are we blinded by a romantic ideal? This question is hard to answer because we're prohibited from knowing what actually happens in the deliberation room. So researchers had to rely on alternatives such as examining jury verdicts, surveying judges and lawyers, and running mock jury simulations. According to a mock jury study of deliberation in a terrorism trial, any bias jurors admitted to in their initial survey was mediated by deliberation, meaning that the deliberation process itself reduces bias. A Ministry of Justice study using a simulated trial found no evidence of discrimination against Black minority ethnic individuals in all white or mixed juries. There's also skepticism over whether a jury actually understands what's happening in a trial. But according to Zander and Henderson's 1993 Crown Court study, most jurors said that they understood the facts. Over 90% found the evidence not at all difficult to follow, and thought the jury as a whole understood it as well. 905 of both prosecution and defense barristers said no when asked whether they thought the majority of the jury had difficulty understanding the evidence. Now, the only concern left is that a jury trial is very costly and time-consuming. And in light of the current state of the criminal justice system, it seems that reducing jury trials may help reduce some of the problems. Critics of the jury might argue that the democratic defense of the jury is purely symbolic. There is no concrete empirical evidence that trial by jury is fairer than trial by judge alone. The assumption that judge alone trials produce higher conviction rates remains statistically unproven, and the fear that judges are case-hardened lacks definitive proof. If the jury's democratic function amounts to no more than a feeling of legitimacy rather than an actual difference in output, then is keeping the jury actually worth the cost? And if the use of jury now is causing system-wide paralysis such as delays, backlogs, cases stretching on for years, then justice delayed is justice denied. On this view, restricting the jury actually preserves the democratic integrity of the system by keeping it functional for cases that matters the most. The topic that we discussed today is genuinely contested. I am of the view that the jury system should be kept simply because of my faith in being judged by my peers rather than a single authoritative figure. But I am very curious to know what you guys think, so let me know in the comments below, and I'll see you next time.